Hello, everyone.
Good morning.
I'm Joe Woodfin. You probably know. I'm the rector of St. Peter's, as you can see from my name tag that I'm asking staff to wear, so I feel like it's fair that I wear it too. I'm glad that you're here. I'm going to read to you a paragraph from the prayer book by way of welcoming you and saying that I'm glad you're here, and then I'm going to turn it over to Lee, who's going to introduce Meghann for the seminar. This is on page 445 of the prayer book. It is a rubric, and I remember that it's on page 445 because it was one of those questions on my liturgics exam that the liturgics professor knew that none of us would remember. So it was like the built-in, you're going to get this wrong. But I've remembered it ever since. And this is what the rubric says on page 445 at the end of the service for the Thanksgiving for a Child. The rubric says, "The minister of the congregation," that's me, "is directed to instruct the people from time to time about the duty of Christian parents to make prudent provision for the well-being of their families, and of all persons to make wills while they are in health, arranging for the disposal of their temporal goods, not neglecting, if they are able, to leave bequests for religious and charitable uses." That's one of those binding rubrics in the prayer book that most of us don't know about. So, I'm very grateful that the Foundation for St. Peter's Church does a lot of that work for me. Because I don't know with expertise how to tell people how to leave wills and all of the things that I just read to you from that rubric, but there are people who do, one of whom is here today. So I'm very glad that you're here as I fulfill my duty as minister of the congregation, and you are here to learn some helpful things about estate planning. I will also tell you that I'm not working here from telling you something I wouldn't do. Carly Woodfin and I have had a fairly primitive but an estate plan since we were 25 years old, because we had children when we were 24. So we knew that we needed to do that, and we did it. So I'm glad that you all are here to talk about estate planning. I'm going to hand it over to Lee Coulter. Thank you, Lee.
Thank you. And good morning again. Thank y'all for being here. And I'm glad that some of you who missed us last time, 3 years ago, were able to come back. And Lisa Sato, as you know, is filming this, so we're hoping to put it up on either the website or our YouTube channel so that people can reference it later, especially if they've had to miss this session. I'm here, excuse me, to introduce Meghann Allen to you. Meghann is an attorney here in town. She and her family moved here originally about 15 years ago. And I'm not going to go through the bio in terms of education. She's an attorney, you know she has to have one. So she is also a member of the Florida Bar, and her son, sick, is in the library, so very proud of him being so good. You know, on a personal note, Meghann helped me with my mother's documentation, wills, HIPAA, all of the authorizations that she's going to talk to you about today. And it was not only a seamless process for us, but a very kind and personal one. And she did everything she could to make sure my mom was happy with what we were doing, and that I understood, and that when we had questions about who should be in charge of what, she was very kind about making gentle suggestions about who might best serve in those roles. So I hope that is what you're looking for as well, and I'm sure that Meghann will give you all you need to know. Meghann, I'm going to turn it over to you at this point.
Well, good morning.
Good morning.
I'm Meghann Allen. Like Leah said, I'm an attorney here in town. I work with a firm, Amelia Law Group. We have 3 attorneys. We're on the island, and so people like that they can come and that we're close. A lot of legal matters you have to go to Jacksonville for, but we feel that we fulfill that role here on the island. But there's also other good options here on the island too. I prepared an outline of what we'll talk about today, but I know you can read it on your own, but a lot of good points are in here about each document. And so when Lee called me up and said, "Would you like to speak this year?" And I said, "Absolutely, happy to do it." And so I said, you know, we have this long document we give all our potential clients. We call it an overview, and it talks about all the documents. And then we do a questionnaire, and it's about 10 pages of information about you, personal information, financial information, family information that we have all our that the clients fill out in advance. And so that when we meet for the first time, our meetings are more meaningful. We get right down to what's important. But I use my overview to kind of prepare this outline. So this isn't what you would get from us. So you're not a potential client, but this is more for informational purposes only, so that we can talk about the documents that we recommend everyone have, the minimal documents. And so what you see is missing is a trust. And that's because not everyone needs a trust. Not everybody wants a trust. Some people feel either their assets are too simple or they don't have enough. And there's different reasons for having a trust anyway. So we'll talk about that a little bit more too. But you can almost draw a line under or right above the durable power of attorney and think to yourself mentally that the will and a trust are documents that deal with end-of-life planning, right? But the documents below those are really for incapacity planning. And so I kind of like to make that distinction from the beginning, because I think it's really important to realize that you're not just planning for your kids or your heirs and what's going to happen with your property. The second piece of that is just as important. You're planning for what's going to happen if you become incapacitated. Who's going to make financial decisions for you? Who's going to make medical decisions for you? Who's going to basically run your things in the event you're incapacitated and can't? Once you're incapacitated, you cannot make those 5 documents. You have to have capacity to make a power of attorney and the healthcare documents. And so I think those are just as important when I see somebody that we talk about all 6 of these documents, because if you're incapacitated, it's too late. But we'll start with the will. Everyone should have a will, but fear not, if you have not done a will, you have a will. It's in the Florida statutes, and it's probably not what you want. So the statutes of Florida dictate what happens to property when you don't have a will, and that's called intestate. If you do have a will, then it's testate, and the courts then will go through what your will states for how property is divided, who's going to get it, gifts that you want made. A will is very important because there's things you can do in a will that the statute's not going to do for you, like appoint guardians for your minor children. Now, if you have minor children under your care and you do an appointment of guardian, it's not binding on the court. When children are involved in legal matters, it's always the best interest of the child. And so think of it more, it's your preference if that's who you'd want the guardian to be for your minor children. Your last will and testament, you have the opportunity to appoint your personal representative. Many states, this is called the executor. But this is the person that's in charge of the estate and the probate administration process, the court process. And so their job is to gather the assets, to notify creditors, determine if the creditor has a valid claim, pay the valid claims, and then distribute out the assets of the estate, final tax returns. That's what a personal representative does. And so you have the opportunity to appoint one. And in the state of Florida, that person must be over 18, not a felon. They must be related to you by blood or marriage. Or they can be a Florida resident. So there's some requirements, and so one error I see when people prepare their own documents, if they name their dear friend Sally in Georgia, but if she's not related to you by blood or marriage, then she can't serve in Florida. And so, also, when you do your will, you're allowed to distribute the property as you see fit. In the statutes, there's going to be a list of who gets it and how much, and it depends on if you have children, if the children are your children, or if there's children that stepchildren involved. So the will allows you to dictate who receives property, what percentage, and also you can make gifts. So if you want to do charitable gifts to charitable organizations or churches, and I've got to tell you, the Humane Society on the island gets a lot of gifts. People love their pets. I would say that's the most common charity I see. And you can tell from
St. Peter's would be
exactly. But so that's the proper place for that to happen in the will. Something else people are always worried, always concerned, you see on TV the reading of the will, very exciting stuff. Well, estate planning is just really not that exciting. And what they're reading generally is not usually the will. They're reading kind of what we call in Florida the separate writing. So our will has a provision in it that says I may gift articles of tangible personal property outside my will in a separate writing. The most recently dated and signed will rule. And so when you see on TV, I give my jewelry to my niece, that's what they're reading usually. But tangible personal property is something you can touch. And so we're thinking of heirlooms, the silver, the jewelry. Those are the items that belong on the tangible personal property on that separate writing. And so our will allows you to create one of those. And the greatest thing about the separate writing is the flexibility, and you don't have to see me to update it because the most recently signed and dated rules, so you can update those on your own, which is kind of nice because our assets constantly are changing. So that's kind of the will. So we think about, we're still at end of life planning, and let's think about, would I need a trust? What does a trust do for me? And there's two kinds of trusts, revocable and irrevocable trust. Irrevocable is kind of out of the realm of this discussion. It's usually for tax planning, and moving assets out of your estate. And so I'm thinking more of the revocable trust, a grantor's trust, and that can be used for we call it sometimes a will substitute document. Doesn't mean you're not going to have a will though. With our firm, you'll always have a will. We have a pour over will that says everything goes to my trust. The trust can be used for privacy because it's not filed in a court record. The trust can be used to control assets after you pass. So if you can have a trust inside your will, but it's called a testamentary trust, and that still will go through the court administration process, and the trust will be governed by the courts throughout the lifetime of the trust. If you set the trust up during your lifetime in a grantor's trust, then it doesn't require court administration. You've already named the people that are in charge of the trust, the successor trustees, and the trust, it maintains itself after you pass. The trust can be used, like I said, to control assets after you pass. So the trust dictates who's going to receive, how they're going to receive it, when they're going to receive. If something happens to that beneficiary, then who receives it. And so it's comprehensive so that it continues on without any issue. So if you have a beneficiary that has a substance abuse problem and they don't need to receive a lot of money because it could be their ultimate downfall, you wouldn't want them to receive $500,000. You can set up a trust to benefit them. Somebody who's under disability, you generally don't want to receive assets because it could disqualify them from government benefits. If you have two couples come together and they have marriages, previous marriage and kids from previous marriages, maybe each spouse wants to set up a trust that benefits, they keep their assets separate and then benefits their children separately. I think the trust benefit that is usually you think of is that you can avoid probate administration in the court system when you pass. And so you do that by funding the trust with your assets during your lifetime so that the successor trustee steps in and handles the assets so that court involvement is not required. Any questions so far?
Megan,
Yeah.
the court doesn't become involved, but do you keep the counsel of the attorney to help you administer that trust?
Once the grantor, the person that establishes the trust, often in other states called the settlor, once they pass and they're no longer the initial trustee, they've named and dictated who the successor is going to be. Okay. That person automatically will control how the trust is handled, and they can hire their own attorney, so they can go back to the drafting attorney and use them, or they can use any attorney. But it's recommended that they do so that they can ensure that they've been appointed properly and they have the authority to act. And then, trusts are hard to read. They just are, they're hard to read. And so often the new trustee is gonna wanna know what are the terms that I can give the principal or income to the beneficiaries under their trust. They're just difficult sometimes to read. That's a great question. Any other question?
You said that relative to being an executor of a will, it either has to be a family member by blood or a Florida resident. What about a stepchild? Or
marriage. So if they're a family member by marriage, then that would qualify. So yes.
So my stepchild could be the executor. Okay.
Yeah. All
What about trustees?
Yeah.
You know, of the trust, do same rules apply, or can you have out-of-state people?
Oh, no, trustees are fine. Trustees have no rules of who can serve as a trustee. You wanna pick somebody that has good acumen when it comes to finances, that has relatively the same judgment you're gonna have, because often they're making judgment calls on distributions. But there's no, requirement on who can serve. Yeah. So that is the will and the trust. Those are the end-of-life documents. The trust also can step in the event of your incapacity. If you fund your assets into the trust during your lifetime and you become incapacitated, there's provisions in our trust that allow for the successor trustee to step in and then handle the trust assets. So our trust is kind of in that dual range of end-of-life planning plus incapacity planning. The other documents that we always recommend are the financial and the healthcare documents. And so I'll go through each of those. The durable power of attorney, everyone's heard about a power of attorney and they know it's important. The power of attorney is where you name who can handle your financial affairs in the event you're unable to. We make ours as long and broad as possible because we want things to continue on in the event you become incapacitated. The alternative to a durable power of attorney is a guardianship. If you don't have somebody named that can act in your stead for financial and legal matters, then you have to have a court-appointed guardian appointed for you. So ours deal with real property, tax, litigation, gifting, post office tax filings, IRS filings, and so ours is it's 14 pages long. In Florida, there's a special provision that requires any estate planning powers that you're giving your agent to be initialed. And so that's when I see durable power of attorneys prepared on your own or prepared through the internet, I see that's not there usually. The durable power of attorney, again, it allows someone to make these decisions for you in the event you're not even in the event you're unable to. That's the key to the durable power of attorney, is the person you've named can act immediately. And in Florida, a copy is just as good as an original durable power of attorney. So it's a big responsibility for the person that you've named, and they are under a fiduciary obligation to do what they've been allowed to do in the durable power of attorney and to do what you would want them to do. Except if you're doing real estate transactions in Nassau County, you have to have the original. So, any questions on a durable power of attorney, Lee?
So, I remember with my dad, I had the durable power of attorney, but some of the financial institutions wanted us to sign their own documents. Is there a way to take what you have to the financial institution and?
Yeah, you can, they have their own obligations to assure that it's correct. So what will often happen is they'll take the durable power of attorney and say that they have to run it through their legal department. And that unfortunately can take a few days. So that's been a frustration. So if you've been named to a power of attorney for your parent and they bank religiously at some bank, go ahead and find out what the steps it is to be, you can be a signer on their account or have authority over their account without actually being added as an owner or even having the power to withdraw money. That's always a good idea as well if you're the primary caretaker for an elderly person. You don't want to be added as a joint owner because then your creditors become the creditors as well in the event something were to happen to you. You don't want to put their assets at risk, because that happens very common too. Someone's taking care of someone and they just add their child as a joint owner. Yeah.
So what you're asking for is to be a signer?
Like a signer or just have authority on the account, but you don't want to be added as a joint owner. Yeah.
Does Florida recognize Georgia documentation in this, top to bottom? We just moved from Atlanta, so we're just trying to figure out.
No, great question. We find that I've been dealing with most of my new clients are transplants that have just come and moved here, and so they have existing documents. If they were properly executed in the state where you sign them, then they'll be honored here, which is a great question. But we find that our clients want them updated for Florida because they're trying to establish Florida residency. And so we have a checklist for establishing Florida residency, and one of them on there is to redo your estate planning documents, because in the documents you generally state, I'm a resident of, I live at this address, and so it helps establish if you need to establish a case for residency. It helps with that. Yep. So that's finances. The other documents deal with healthcare. So the designation of healthcare surrogate, it's kind of like a durable power of attorney for healthcare. This document is in the event you're unable to make medical decisions for yourself. Maybe you've had an accident and you're in a coma and medical authorization needs to be approved. In this document, you name who you'd want the doctors to reach out to for that. We recommend multiple people in this role as your healthcare surrogate, and it's not end of life decisions. This is in the event you're unable just to make medical decisions for yourself at that time.
Who makes that decision
Who makes the decision
that you're unable?
to make it's obvious, like if you're in a coma and they can't, you're incoherent, that kind of situation. Yeah.
Excuse me, remember that also includes if you have dementia or Alzheimer's and you can't make a reasonable decision, there needs to be somebody there to do it for you.
Yeah, so if a doctor has has signed off, which they're very hesitant to do.
Yeah.
But if you do have a family member that is completely diagnosed with dementia, Alzheimer's, and the inability for decision making, then that would indicate that they would need somebody else to make those medical decisions. But if they're able to make their medical decisions, then they are going to be able to do that. The living will is, oh sorry, yeah.
You said you recommend multiple people?
As for alternates, so your primary surrogate, and then an alternate and an alternate, because if they're unable to reach the first one, so if there's been an accident and you're in a coma and they're unable to reach that person, but they need an immediate decision, they can go to the next one, and that's how our document reads. It toggles between your primary and your alternates. So each instance that arises, they'll start with the primary. If they can't reach that person, then they'll go the alternate to the alternate, and then a second incident arises, they'll start with the primary, alternate. Absolutely. The living will, that is the end of life declaration. It is a Florida statutory form. And so this is if you're in if you're terminally ill, end of life stage, persistent vegetative state, it's a statement that you don't want to be kept alive by artificial means, heroic measures. I usually don't tweak this one. I don't get into too much of a discussion with this one. I say, let me prepare it and you read it and decide if it matches with your goals or not. But it is a Florida statutory form. And on this one, I often just see it as a statement, but in our office, we recommend you name agents to enforce the living will, just like with the healthcare surrogate, you name surrogates. Our living will, there's an opportunity to name a surrogate to enforce the living will, and we see this come up in events where there's a family member that comes in and passionately says she would not have wanted to be put off life support, that's not what her intent is, even though she has the statement's there, and then you're in an argument. But if you name a surrogate to enforce the living will, then that person can step in and say, no, I've discussed this, here's her statement, and I would like to enforce the living will. And so, any questions on those two documents? I think those kind of go hand in hand a little bit. The pre-need guardian declaration, I've never seen it in another state. I think it's a relatively new document. And I think it's primarily because in Florida we have a large elderly population and there's an ability to take advantage of them. Their caregivers can take advantage of them. And so caregiver comes in, husband and wife are living together, husband needs extra care and caregiver decides that husband's not receiving the care he needs, and the caregiver decides to file in court to be appointed that husband's guardian, even though the spouse is right there. And so a guardian, you can get guardianship powers over the person and the finances. And so the declaration of pre-need guardian we prepare prior to incapacity being an issue, and that says if a guardianship proceeding has been commenced, I would want this person to be my guardian. If that person's not available, then this person. It's usually my spouse, my children, family members. This doesn't get filed in advance anywhere. It stays in our file. In the event we find out that a guardianship proceeding has commenced, we'll file it in the court record so that they'll know what your preference was when you had capacity. Because when a guardianship proceeding is happening, capacity is the thing that is at issue. And so it's best to have the document prepared prior to it.
How do you know if it's been filed in the court, though?
It's not filed unless we do it. So.
Yeah, but I mean, if somebody else
if-
files for guardianship.
Usually it's the person that has been named, that the spouse or the child that had been named as the guardian preference would let us know that somebody else is petitioning to have a guardian appointed, but here I am, I'm their durable power attorney and their healthcare surrogate, we have this covered. You know, no one's gonna keep someone from filing a guardianship proceeding if they wanted to do it. And so this would allow that person to come in and say, do we have anything we can show that every intent was there, that I am the person's durable power attorney, healthcare surrogate, and if a guardian's needed, it would be me, and then that where we would have the declaration. Yes.
So this brings up a larger question that you might address more generally at the end too, Meghann, but when it comes to communication about who you've designated as these things, is for all of these categories, are you legally required to notify someone that you've named them?
That's a great question, and I've had people ask me, does my son need to come to this meeting because I'm naming him personal representative? And so really good question. No, everything you do is personal and confidential. If you bring a child to our meeting, it's not confidential. You've just broken that confidentiality, actually. And so I've been asked, what do they need to know? Who needs to know? And you're naming people you love, you trust, that are gonna look out for the affairs in the event of incapacity or when you pass. So I recommend the more you tell them, the better, unless there's a really good reason not to. But you don't have to tell them. They do not sign anything accepting any fiduciary responsibility or appointments, because one, you can always change it. Nothing in here is permanent. And so when you do your will, it shouldn't be the first time you do it. You're gonna do it again. And second, I forgot my second. That you can always change it, and they don't have to accept the appointments. So you've named your son as your personal representative, and he is just stricken with grief that you've passed, and he can't do it. And so he doesn't have to accept to be your personal representative, and it would go to your alternate, and then they could step up. And so that's why no one ever signs on his acceptance. I've seen documents where successor trustees accept, but it's too early. They're not appointed yet. If you're the trustee of your trust, your successor doesn't need to sign on yet because they haven't been appointed. They may not be around by the time that it comes for them to be appointed. And so we do recommend the healthcare document, the healthcare surrogate designation, living well, and the HIPAA authorization. We recommend you give those, a copy of those to the people you've named in them, and we actually provide our clients with extra copies of those to give out. And we recommend that you take them to your regular attending physician so they can put them on file with the medical provider that they're with. And if you ever change them, you just give them new ones. So that's a great question. All right.
Where does the HIPAA authorization come into? Where is that?
Oh, that's a great question. So our HIPAA form says that anyone I've named in my will, durable power of attorney, trust, healthcare surrogate designation, living will, anyone I've named in a fiduciary capacity, when they're acting as that fiduciary capacity, they can access my medical information. And that's so they can make informed decisions. So that comes in that sense. It's a broad who can access it. If you have complex documents, sometimes we name attorneys at our firm as well so that we can assist. Yeah. So if you've done estate planning or are thinking about doing estate planning, often it's overwhelming. It's very overwhelming, and I've been doing it for years, and so I'm comfortable when I talk about these things, and I often forget that it can be uncomfortable for other people. And so some things you want to think about before you come, it's laid out in our questionnaire, and I think that helps a lot of people organize their thoughts, organize their beneficiaries, organize their finances. And so the things in our questionnaire that we ask are fiduciaries. Who would you want to serve in the role as personal representative in the will? Who would you want to be the durable power of attorney for you? Who would you want to be a guardian for minor children? Who would you want to make medical decisions for you in the event that you're unable to in the healthcare surrogate? And to think about those in advance and think about alternates. And if you're stuck, then we absolutely talk about, what makes a good personal representative. What are the attributes that you want to think of somebody who has these attributes that would make those decisions for you or act best in that situation. And also we want you to think in advance about, the assets you have and how you want them distributed. This is very custom to the person because we don't all walk around with the same assets. We all, you could have one piece of real property, you could have multiple pieces of real property in other states. That makes it a completely different meeting. You want to think about financial accounts. You want to think about your IRA accounts. You want to think about life insurance and all your accounts. So you want to think about what you have and who you want it to go to. And one of the most important things is you want to check on all your account beneficiary designations in your checking accounts, at your bank, with your retirement accounts, with your life insurance. These are so important because you did them probably the day you set up the account. And so hopefully they're still what your intent is, but oftentimes it's not. And so you want to make sure that you've named a primary beneficiary and you've named alternates. They call them contingent beneficiaries as well. And while this is even more important is because you may draft the perfect will of here's what I want and this is who I want it to go to, but you set up your brokerage account 10 years ago and you listed somebody else as your primary beneficiary, that is going to overrule. That's what's going to happen. The beneficiary designation, not what you say in your will. The will not overwrite those contracts that you made with those financial institutions on who you want your beneficiaries to be. So it's really important. That's kind of the first homework you get is to check and make sure you've done all your beneficiary designations are to look into them and see who's your primary and who's your contingent. And then I often get the question of, when is a probate necessary? You don't always have a probate estate. Probate is required for assets that are in your individual name alone that don't have some sort of survivorship designation or beneficiary designation. So the most common asset that pops into my head is real property. So you have a house and it's in your name alone. That's going to require a probate administration to pass it to the next person. And so you can have it in your will who it goes to, or you can dictate in a trust. So one reason people use trust is so that they can retitle the real property into the trust during their lifetime, and then that can avoid probate. So what is probate assets? It's anything in your individual name that doesn't have a beneficiary named or a survivorship designation.
Isn't there a financial limit on that as well? Of like, I know in Georgia it's $1 million. Under $1 million, it doesn't necessarily have to be probated, but I don't know about Florida.
No, every state has its own rules, and I only know Florida, but I have heard vicious rumors about Georgia. I will not touch it. No, and it's required, and the rules are so different. So in Florida, there are different probate administration possibilities. We have a summary administration for if your estate is under $75,000. So that's $75,000. That's it. So that's a really low bar. Other than that, it's a full-blown administration. And there's other little smaller processes, but those are really specific. I don't know Georgia. I know, and I also know in Florida that if you're going to file for probate, you need to have an attorney. Usually, so it's different in Georgia. It's very different in every state. It's very different. One thing that's interesting, if you have other real property in another state, so if you have a vacation home in Virginia, that requires its own probate as well. So if it's in your individual name, and so if a single person, they live here, they have their homestead here, they also have a vacation home in Virginia. They have to have a probate here for their house here, and then they have to open an ancillary probate in Virginia to transfer the home by whatever the will says because it's in another state. And so that can be costly as well. So you'll see vacation homes, sometimes they get transferred to an LLC if they're making in other states. There's ways to, there's strategy to avoid the second probate, but.
Can you avoid it by putting it in a trust?
Mhm. Yep, and that's our recommendation usually, especially if it's not being used to, as like a rental property, not making money and there's no liability issues there. So yeah, absolutely. So there's a lot of things to think about it, but I always say estate planning is incredible. It's just custom. It's just, everyone's different. No one's walking around with the same beneficiaries, assets, children, issues. It's all very custom. Nothing is which is why the internet forms usually don't work. There's no one form fits all. It's just a very custom process, and there's lots of questions, and so you can't ask the computer your questions. You could try, but usually you don't get a good answer. So, any other questions?
If you had to, let's say you're like, I don't wanna do all this, what is the one thing that you think is the most important to prepare?
Well, that is not fair.
I know, I'm sorry.
I truly do believe all
I know.
6 of these are just as important, because estate planning to me is not just end of life planning. It's not just where are my assets gonna go. We don't know when we're gonna become incapacitated. We have no idea when you would need these other documents. The durable power of attorney, for instance, is helpful just if you're out of the country and you needed someone to access your financial banks for you. So
That's important to remember. I'm glad you brought that up, because incapacity is not necessarily in a coma. You know, I know
no.
both of my parents, as they get older, they don't hear what the doctor says, or they don't remember what was said or what was supposed to be done, and so, yeah, it makes a difference.
Yeah, we don't know when we need these documents, so I couldn't pick one. It's like picking your favorite child. There's no such thing. No, they're just all so important, and I often do have people that come in, I just want the will. I'm thinking, but you're not seeing the big picture past just the will. You know, I know you're preparing the will because you want to make sure your children are taken care of, but what if your accounts lock up and your children have to go through a guardianship proceeding in order to access your finances or to be appointed as your medical representative? That's going to affect them more than you didn't have a will sometimes. So they're all very, very important documents.
Relative to Florida law / statutes, and then adding trust to your 6 documents, which are most important to rewrite from a Florida standpoint?
That's a really good question too. It depends on what your intent is for the trust and the wills. Again, if you're trying to become Florida residents, then we usually recommend you redo it. If you moved here and took the proceeds from your old home and bought a new home here in Florida and declared it your homestead with the property appraiser, there's special language that has to be in your trust to do that. And so the property appraiser is not going to sit there and ask for that specific language. They're going to ask you for the information about your trust, but there is language that needs to be in the trust that says your home, that any real property held in my trust is for my home. This is very complex. Now, at this point, this isn't simple estate planning. Also, this is incredibly complex. Homestead in Florida has multiple beneficiaries to an individual. We all know the tax benefits, and we know that homestead has creditor protection. It also has protection. There's also restrictions on who you can give your homestead to on devise, and it's in the Constitution. It's not very well known because it really doesn't interfere with our daily lives and what we would normally do most times. But when you have a husband and wife and they want to put a homestead in one trust, there's a waiver that we recommend they fill out because it violates the Constitution. And so that's very complex planning, and you should see somebody. The other documents, the durable power attorney, healthcare document, living will, HIPAA, if you came to us to redo your, to update your wills and trust for Florida documents, we would do the other ones for 2 reasons. One, so that they are in the Florida forms that everyone's used to seeing, because you're now seeing Florida doctors and Florida finance institutions usually, maybe not. But we'd also recommend you update them because most likely you hadn't done them for 5 or 10 years. And the laws do change, and we do tweak them. And we do have parts in our durable power of attorney. It's very broad and it encompasses a lot, and I don't see them as broad in other states.
What about trusts for grandchildren?
An irrevocable trust. So that's beyond the scope of this. And as you know, they're irrevocable, so there's not much you can change.
So there's no need to change.
No, oh no, there's no need to update an irrevocable trust. Sorry, I forgot the original question. Yep, that would stay, and everything you're doing for that, you would continue to do. If it's life insurance funded, you would continue to do that and pay the premiums.
You just brought up, the topic of time too, so how often or what life events would you recommend to be
Yep.
the catalyst and then update your document?
Really good question. I said it before, usually estate planning shouldn't be something you do just once. We recommend looking at your documents and not necessarily calling an attorney, but looking at them and making sure they still say what you want when there's been a death in the family, a birth in the family, a large influx of money, maybe an inheritance. But when something big has changed, then you want to look at your documents and make sure and see if there's any updates that need to be done. Or if you named like someone you've named as your durable power of attorney agent or surrogate has passed, you're going to want to update your documents and make sure, or look at them and make sure the alternates are good, but maybe update them for new folks. Great question.
Are there any other questions that you face when people come in that might be surprising to you, or didn't mean to just throw you a hurdball there, but that somebody comes in and like some of these questions you've heard today, that may be different in Florida than some of the other places. I mean, I know you said Florida's completely different, I get that, but there's some things that people face on a day-to-day basis they may not expect.
Not usually. As much as I love these documents, these aren't documents that we pick up every day. We don't need them necessarily every day. It's kind of our insurance policy on life sometimes. So I don't see, these documents can also sometimes just be hard to read. And so actually what I see most common is if you have existing documents, I ask for them in advance to review them in private, just because I can walk into the meeting and already know what your documents say. And so I'll go through what I read that your documents say, and sometimes it's not what they think their documents say. That's happened a lot lately. Either because they did the documents a long time ago, and over time they just forgot, or they thought it was something else. Or I get, well, that's not what I want. And so I'm thinking, well then, what do you want? No judgment, just what do you want? Let's fix them and let's update them. I'm seeing that a lot lately. Just that it's been a long time since they've done the documents, and they're, in trust during for the child's entire lifetime. Child is now 50.
Yeah.
So they're like, well, I don't want that. And then now maybe there's grandchildren. Well, the trust doesn't have any provision in the event somebody who's a minor were to receive. So if your child were to predecease you, and their children were to receive their share, and they're 15 or 14. Now you're giving $500,000 outright to a minor. They didn't have a standby trust provision. So I'm seeing people are surprised what's in their documents. So yeah, it's usually a process, and they're usually really appreciative because their documents are hard to read. They are hard to read. So unfortunately.
So Rachel asked about communication. Is it a good idea to make sure that the people you're naming as executor and or your living will, your HIPAA authorization, that they all have a copy of these documents?
We usually recommend you give them the healthcare surrogate, the living will, and the HIPAA authorization. The declaration of pretty guardian, not so much. And then the will and the trust are private, and you can change them at any time. We recommend that you let them know they've been named, or you ask them if they are willing to serve as your successor trustee or your personal representative to ensure that you've got someone who is willing to do it. But we don't recommend that you give them copies because you can change it at any time. So it's not, so that they're not stuck with one copy and then we have another copy. I often, one of our biggest questions is, where do you want the originals? Back in the day, the firms wanted the originals. And we still have a will, we have a will safe, but people have just come transitory. and they move. We move more than we ever did. Our children move away, so then we move away to go be with them. And so a question is going to be, where do you want the originals? And when we can keep them here at the firm, but often our clients can take them. You can have a safe in your own home to keep them in, a box at a financial institution to keep them in. So that's a question we often get, is where those should be kept. Good, I think this has been really good.
So everybody have questions answered so far? Great. Megan, thank you so much.
You're welcome. Thank you for the opportunity.
If you have follow-up questions, please let us know, or we'll reach out to Megan. Also, please know that on February 8th and 15th, which are the final 2 Wednesdays before Lent begins, we will have a funeral planning, it's a 2-part seminar, so that in the first part, you can hear the readings and the hymns and the suggestions and see the form that you'll want to fill out. In the second one, we'll make sure, we'll have your form with you and make sure that everyone fills it out and you can get it turned in. I think the biggest obstacle to this point when we've done this is we have them one time. Everybody goes home with their folder and some of them make it back and some of them don't. So if you would like to be here for that, where it will be 10:30 to 12, February 8th and February 15th. We will come with folders with your funeral customary. We will have, as I said, the readings. Tim's going to play the hymns for us. I offered to have him sing, but that went nowhere. So he'll play those for you so you can have an idea of what they are. Again, as with the will and the pre-need and everything else, you think you're not going to need it, but wow, isn't it nicer to have it settled so your children, in the midst of their grief, are not trying to figure out what you would have wanted at your funeral. And both my husband and I have done, I know a lot of people have. A friend of ours who died recently did hers at kind of toward the end, but it was exactly what she wanted, and that's so important to all of us, I think. So we would love to have you there for that as well. If you have questions, you can call me or email me or call Rachel at the office, and we hope to see you then. Thank you.
Thank you.